Have you ever felt a moment so powerful that the whole world seemed to stop? A moment where every breath in the room froze, and everyone waited for the next word. This was one of those moments. The Supreme Court chamber was silent. So silent that people said they could hear their own hearts beating. And all eyes, every single one, were locked on Congresswoman Jasmine Crockett. She stood at the podium, calm, steady, and strong. She looked like she had been born for this moment. But no one, not even the most seasoned legal experts, expected what happened next. Not one soul in that room was ready for the shock that was coming. Justice Stephen Breyer leaned forward in his chair. He was 83 years old, with decades of legal experience. He had heard thousands of arguments. He had questioned hundreds of lawyers. He had listened to some of the brightest minds in the world. But this moment, this was different. Everyone could feel it. Congresswoman Crockett, Justice Breyer said. His voice echoed through the quiet courtroom. In my 27 years on this bench, I have never heard an argument presented with such clarity and constitutional precision. The room exploded in whispers. People gasped. Some covered their mouths. Even the other justices stared at Breyer in surprise. A Supreme Court justice had never praised an advocate during oral arguments. Not like this. Not in front of the whole nation. Not with such bold words. But Jasmine Crockett didn't freeze. She didn't stumble. She didn't blush or smile too big. She simply breathed in, stood even straighter, and prepared to speak again. Because she wasn't finished. Not even close. The morning of the hearing. The day had begun with tension in the air. The marble halls of the Supreme Court were filled with reporters, clerks, and quiet conversations. The voting rights case, Johnson v. Texas Election Commission, had captured the whole nation's attention. It wasn't just a court case. It was a fight over whether millions of Americans, especially minority voters, could still access their fundamental right to vote. Journalists whispered predictions. Clerks hurried past carrying thick binders. Security guided long lines of people waiting for a chance to sit inside the courtroom. What made the day even more unusual was the advocate representing the petitioners. Congresswoman Jasmine Crockett. A sitting member of Congress. Arguing her own case. In the Supreme Court. On an issue that affected her own district. People wondered. Would she be nervous? Would she struggle? Would she break under pressure? No one expected what she was truly about to do. Jasmine Crockett, who she is. Jasmine Crockett was not an ordinary lawmaker. She grew up in St. Louis. She worked her way through school. She paid her own way through college and then law school at the University of Houston. Her life had been filled with hard work, grit, and purpose. Before Congress, she had been a civil rights attorney. She fought police misconduct. She defended voting rights. She represented families and communities when no one else would. She won cases people said she couldn't win. She stood her ground when others backed away. Most of all, she prepared. Always prepared. Every case, every detail, every document. And now she was standing in the most powerful courtroom in America. Facing 9 justices. Facing the entire country. But she didn't tremble. She didn't rush. She didn't panic. She was ready. The Texas law at stake. The case challenged a Texas law that had shut down over 300 polling locations. Most of those closures were in minority communities. People in rich, mostly white neighborhoods barely felt the change. They actually got more polling places. But in Crockett's district, people now had to travel miles, sometimes 20 miles, to vote. For many working families, elderly citizens, and people without cars. That wasn't just hard. It was impossible. Texas said it was all about efficiency. But Crockett had evidence. A lot of it. And she was ready to show the court everything. Enter the Supreme Court. When Crockett stepped to the podium, she carried only a thin binder. She dressed simply. No flashy jewelry. No dramatic gestures. Just confidence. Chief Justice Roberts started the questioning. He said the law didn't mention race. He said the criteria were neutral. He asked how Crockett planned to show discriminatory intent. Her voice was calm. "Mr. Chief Justice," she said, "we show intent through history, procedure, impact, and evidence." Then she explained the Arlington Heights framework step by step. She cited every detail from memory. She spoke so clearly that even people who didn't know the law understood her. The courtroom shifted. Everyone leaned in. Even the justices. Justice Thomas jumped in. His questions were firm. But Crockett answered with exact numbers, percentages, and facts. Justice Barrett asked about burdens and legal tests. Crockett responded with a GPS tracker showing a heartbreaking example. A 72-year-old woman taking 3 hours each way by bus just to vote. Justice Alito tried to challenge her evidence. Crockett agreed with him first. Then revealed that she had comprehensive data, not just stories. For nearly 40 minutes, she faced rapid-fire questions. But she never hesitated. Never stumbled. Never lost her place. She answered like someone who had lived this fight. Like someone who knew every corner of the law. Like someone who had prepared for this moment her whole life. The moment of silence. Then, Justice Breyer spoke. This was the moment everyone feared. Breyer was known for long, complex hypotheticals. Most lawyers dreaded his questions. They could twist a simple issue into a maze of legal puzzles. "Congresswoman Crockett," he said. "Let's consider a hypothetical." The entire room inhaled. Breyer described a law using Social Security numbers. Neutral on its face. Discriminatory in effect. Most lawyers would take minutes, or stumble entirely, just trying to understand the question. Crockett paused for a few seconds. Then she spoke. Her answer connected history, precedent, logic, and fairness all at once. She cited cases from the 1800s and modern decisions. She explained constitutional principles in simple, powerful language. People in the room said the air changed. Even Justice Breyer leaned closer, nodding. No one in the courtroom missed it. Jasmine Crockett had just turned one of the hardest questions in the Supreme Court into one of her strongest points. That was the moment when even the doubters realized. She might actually win. The unexpected praise. And then it happened. The moment no one expected. The moment that would become famous. Justice Breyer looked directly at her. "In my 27 years on this bench," he said, "I have never heard an argument presented with such clarity and constitutional precision. You could have heard a pin drop." The Texas Solicitor General froze. Reporters stared. Clerks exchanged looks of disbelief. Even Chief Justice Roberts glanced at Breyer in surprise. This didn't happen. Ever. But it happened today. And it happened for Jasmine Crockett. She thanked him. Then turned the moment back to the voters she was fighting for. The room shifted again. Respectfully. Powerfully. Everyone knew they were witnessing something historic. And it was far from over. Sometimes a question is not just a question. Sometimes a question is a test. A moment that reveals everything. A moment that decides the future. That is exactly what happened next. Justice Breyer leaned back, then slowly leaned forward again. His eyes locked on Congresswoman Jasmine Crockett. The room went still, completely still. People sensed that something big was coming. Something heavy. Something that would push this case into a new direction. And then he asked it. A question so direct and so sharp that journalists later called it the moment the Texas case began to fall apart. The question that shocked the court. Justice Breyer said. "Congresswoman Crockett. You have shown evidence of a strong correlation between the law's formula and the racial makeup of affected areas. But correlation is not causation. We must be sure. So tell us. What proof do you have that the Texas legislature knew this law would harm minority voters before they passed it? The words hit like a strike of lightning. Because this was the heart of the case. This was the key. This was the question that could win or destroy her argument. If Jasmine Crockett could not prove intent, if she could not prove knowledge, then the case might collapse. People leaned forward in their seats. Reporters lifted their pens. Even the other justices waited, silently. And Jasmine Crockett did not flinch. She didn't search through papers. She didn't look confused. She didn't hesitate. She simply lifted her head and answered. The 3 pieces of evidence. Justice Breyer, she said. We have 3 clear pieces of evidence. She held up one finger. First, we have a statement from the bill's sponsor, Senator Williams. He dismissed concerns about minority voters by saying, if they really want to vote, they'll find a way. A few people in the gallery shook their heads. Others frowned. It was a cold statement. A careless statement. A revealing statement. She held up a second finger. Second, we have emails between the governor's office and legislative leaders. In these emails, they calculate how many Democratic votes would be reduced by targeting specific areas that are mostly minority communities. Reporters began writing fast. You could almost hear the scratching of pens. She raised a third finger. And third, we have testimony from a former legislative aide. This aide was inside closed-door meetings. They heard lawmakers talk openly about using neutral language as a mask. A mask to hide criteria designed to reduce minority voting. The courtroom felt colder. Still. Heavy. Because this wasn't speculation. This wasn't guesswork. This was evidence. Straightforward. Direct. Hard to deny. Justice Breyer nodded slowly. He didn't smile. He didn't speak. But his eyes showed something clear. Respect. The state's lawyer panics. The Texas Solicitor General jumped to his feet. He spoke too fast. Your Honor, we object. Chief Justice Roberts cut him off. Counsel, this is not a trial court. There are no objections here. The Solicitor General froze. This was the second time he had made a mistake. You could see the frustration on his face. His hands tightened on the podium. His voice trembled. He had been rattled. And everyone could see it. When he finally spoke, he tried to repair the damage. Your Honors, these claims are not credible. The Fifth Circuit Court found the aide's testimony unreliable. Justice Sotomayor stepped in. On what grounds? The District Court found the witness highly credible. The Fifth Circuit dismissed the testimony without explanation. The Texas lawyer looked cornered. He flipped papers. He paused too long. He looked confused. The justices noticed. The gallery noticed. The viewers watching from overflow rooms noticed. The momentum was shifting. And it was shifting fast. The justices pressed harder. Chief Justice Roberts asked the first sharp question. Counsel, what about the email discussing the partisan advantage gained by closing certain polling places? Are you denying the email is authentic? The Solicitor General swallowed hard. Your Honor, the email discusses partisan effects, not racial ones. Justice Kagan interrupted. But the email also says, and I quote, 90% of the impact will be on minority communities, which works out perfectly for our purposes. Is that correct? Silence. The Solicitor General tried to find the words. Justice Kagan, that comment is taken out of context. Kagan lifted the paper in her hand. This is the entire email. More silence. The Solicitor General finally looked down. He didn't answer. Because there was no answer. And the courtroom felt the shift. Justice Thomas spoke next. His tone was serious. His question was deep. Counsel, under Section 2, the issue is not whether the state created the conditions, but whether the system interacts with those conditions to deny equal opportunity to vote. How do you address that standard? It was a trap. A legal trap. A precise trap. The Solicitor General had nothing. He tried to circle the question. He tried to speak vaguely. But Thomas pressed harder. Justice Barrett joined in. Justice Gorsuch followed. It became clear. The justices were no longer focused on Crockett. They were focused on the weaknesses of the Texas law. And they were not buying the state's excuses. Justice Breyer's final blow. When the Solicitor General looked weakest, Justice Breyer delivered the final strike. Counsel, he said. Do you believe a law that prevents a large number of minority citizens from voting is still constitutional? As long as the text of the law appears neutral? The Solicitor General opened his mouth. He tried to answer. But no clear answer came out. He fought for words. He searched for logic. He tried to build a defense. But the question was too sharp. Too precise. Too clear. When he finally spoke, it came out weak. Justice Breyer, if the criteria are neutral, and the state has a legitimate purpose. Breyer interrupted. What about the aide's testimony? The private study? The correlation analysis? The emails? The Solicitor General had no strong reply. And everyone knew it. Crockett returns for rebuttal. Chief Justice Roberts looked at Jasmine Crockett. Congresswoman, you have 4 minutes for rebuttal. She approached the podium again. Calm. Focused. Steady. Thank you, Mr. Chief Justice. Her voice filled the chamber. She spoke plainly, simply, and powerfully. Her message was clear. The right to vote is fundamental. When barriers rise, democracy falls. And the Texas law did not create a level field. It created a wall. She reminded the court of the evidence. The emails. The data. The secret meetings. The study that predicted the exact racial effect. Then she spoke a single sentence that later appeared in newspapers across the country. The question before this court is whether the Constitution allows sophisticated discrimination to succeed where simple discrimination would fail. The room vibrated with silence. This was not emotion. This was precision. Legal precision. Moral precision. Her final line was soft but powerful. We ask this court to protect the right that protects all other rights. Thank you. And the courtroom stayed silent even after she walked away. Because everyone understood how serious this moment was. After the argument. When the hearing ended, the nation reacted instantly. Outside the courthouse, the steps were packed with microphones, cameras, and people cheering. Reporters broadcast live. Commentators called her argument one of the greatest Supreme Court performances in years. Even critics admitted she delivered a masterclass. Inside Washington, the story spread like wildfire. Clips of her answers went viral. Lawyers debated her precision. Professors praised her clarity. Voters said they felt represented. Justice Breyer's praise became a headline by itself. People said they had never seen him so openly moved. But something else was coming. 3 weeks later, Justice Breyer announced his retirement. Some wondered if the case influenced him. Some said he was passing the torch. Others believed he saw something in the new generation, something powerful. But the truth would not be clear until the court released its decision. And that decision, that ruling, that historic moment, would shake the nation. And that part of the story? That part comes next. The whole country waited. Days passed. Then weeks. People checked the news every morning. Commentators argued on TV. Lawyers wrote long articles. Voters wondered if anything would change. Communities across Texas prayed that the Supreme Court would protect their rights. And inside Washington, the justices worked quietly behind closed doors. The country didn't know it yet. But something historic was taking shape. The Supreme Court's surprising move. After 2 long months, the Supreme Court finally announced the date of the decision. The whole nation stopped. You could feel the tension in the air. News alerts spread like wildfire. Supreme Court to release ruling in Johnson v. Texas Election Commission this morning. People gathered around phones, televisions, and radios. Lawyers rushed into their offices early. Reporters filled the sidewalks outside the court. Inside her small congressional office, Jasmine Crockett sat with her team, waiting quietly. She looked calm, but everyone around her could feel the weight of the moment. This wasn't just a legal decision. This wasn't just political. This was about real people. Millions of them. People who had been pushed away from the ballot box. People who just wanted their voices heard. The ruling is released. Finally, the opinion was published. Reporters immediately scrambled. Pages printed. Cameras turned on. Heads dropped and lifted as people read the ruling line by line. And then the news exploded. Supreme Court strikes down Texas voting law, 6-3 decision. People gasped. 6-3? That meant something rare. It meant conservatives and liberals on the court had found agreement. It meant the case wasn't political. It was constitutional. Inside the courtroom, the ruling showed the lineup. Chief Justice Roberts. Justice Breyer. Justice Sotomayor. Justice Kagan. Justice Gorsuch. Justice Barrett. These 6 justices voted to strike the Texas law down. The decision was written by Justice Breyer. It would become one of the most important voting rights opinions in decades. The words that made history. Justice Breyer's opinion was clear and firm. He explained that the Constitution does not protect surface neutrality. It protects real people and real voting rights. Then he quoted a line from Jasmine Crockett's argument. A line spoken in a calm voice in that silent courtroom. The Constitution nullifies sophisticated as well as simple-minded modes of discrimination. Those words appeared in the middle of the Supreme Court decision. They were printed in newspapers the next day. They were studied in law schools. They were repeated on the news. Millions of people who had never heard of Jasmine Crockett now knew her name. Justice Breyer wrote that courts must look deeper than just the text of a law. They must examine its real-world impact. Its effects. Its purpose. Its hidden motives. And then came the sentence that changed voting rights law. When lawmakers use neutral language to disguise discriminatory outcomes, the law remains unconstitutional. With those words, the Texas law collapsed. The immediate impact. Texas was ordered to reopen the closed polling places. And not just reopen them. They had to distribute them more fairly across communities. Within weeks, old polling sites were restored. In some places, new ones were added. Elderly voters who had once traveled miles now had polling locations just around the corner again. Workers who couldn't afford long bus rides now had access to early voting nearby. Families who had once been discouraged now felt included. The next election saw something incredible. Voter turnout in the affected areas grew by 37%. That number wasn't just a statistic. It was a message. A powerful message. When you remove barriers, people show up. When you respect voters, they participate. When you protect democracy, it grows stronger. The country responds. Legal experts reacted first. Harvard law professors called the ruling a new landmark. Judges around the country cited it in new cases. Voting rights groups in other states immediately filed challenges to similar laws. And in community centers, churches, and living rooms across America, people celebrated. For many citizens, this wasn't about politics. It was about fairness. It was about dignity. It was about being able to cast a simple vote. People saw Jasmine Crockett not just as a congresswoman, but as someone who stood up for them in the most powerful courtroom in the nation. Justice Breyer's retirement. A surprising moment came shortly afterward. Justice Breyer announced his retirement. In his farewell interview, a reporter asked him, "Was there a case that changed your thinking in your final years on the court?" Breyer paused. He looked thoughtful. Then he said something no one expected. "There was one argument," he said, "that reminded me why constitutional principles matter so deeply. The voting rights case argued by Congresswoman Jasmine Crockett. Her clarity and preparation illuminated issues in a way that will stay with me." Those words spread everywhere. People realized that Jasmine Crockett hadn't just won a case. She had influenced the thinking of a justice who had shaped American law for decades. The long-term impact. Over the next few years, several states changed their voting laws voluntarily. Others faced lawsuits using the new Supreme Court standard. Polling places became more accessible in many communities. Voter participation increased in multiple states. Courts took a stronger stance against disguised discrimination. Law schools added Crockett's argument to their reading lists. Professors taught her methods. Students studied how she structured her answers, used data, and stayed calm. She became an example of what careful preparation and clear thinking can achieve. Where Jasmine Crockett went next. Even after this historic victory, Jasmine Crockett stayed grounded. She focused on her district. She worked on issues that affected families, workers, and children. She gave speeches, not about herself, but about the importance of the Constitution. She reminded people that democracy needs defenders not just in Congress, but in communities, in schools, and in homes. When asked if she saw herself as a national figure, she smiled gently. "I see myself as someone doing the work," she said. "The Constitution belongs to the people. My job is to help protect that." Her humility made people admire her even more. The message that endures. The lesson from this entire story is simple. Truth matters. Fairness matters. Preparation matters. And one person's courage can change a nation. The Supreme Court chamber may have fallen silent that day, but the impact of what happened there still echoes across America. Millions of voters can now cast their ballots without impossible barriers. Communities once ignored are now included. And the principle at the heart of the Constitution, that all citizens are equal, was defended in the place where it mattered most. And if this powerful story moved you, if it reminded you why voting rights matter, if it showed you how one voice can change history, then don't leave just yet. Because your support helps stories like this reach more people. If you found this story inspiring, please like this video. It helps our channel reach more viewers who care about fairness and justice. And if you want more stories about history, law, and moments that shaped America, then make sure to subscribe and tap the notification bell so you never miss future episodes. Tell us in the comments, what part of this story surprised you the most? Your voice matters. Your thoughts matter. And just like in this case, every voice makes a difference. Thank you for watching. And we'll see you in the next story.